Dear colleagues, can you please help me welcome our next speaker, Suzanne Wallace from Moraine Agnew Lawyers. She's an experienced lawyer who holds a Master's of Law in Health Law, and she specializes in management of civil litigation of medical malpractices. Suzanne?
Claims against health professionals are on the increase. Not only sexual harassment claims, but claims in general, particularly in the medical context. Recent cases highlight particular areas of concern where professional lines are blurred due to friendships being formed or just casual interchanges between people. So today I'm just going to give a bit of an overview of recent issues in relation to sexual harassment claims in general and what to do if a complaint is made. Sorry, I'm not sure. Sexual harassment can be obvious or more overt or subtle conduct. The conduct might arise even where there's seemingly a consensual type relationship, but generally involves some inequality in the relationship. Sorry, these are the things that I'm going to look at today, just the complaint process, dealing with the complaint and minimising risks. So the overt conduct is generally fairly easy to identify, but even a recent case before the tribunal emphasised how lines can be blurred. In a particular case, a GP treated a patient for a mole, did a check on the mole, and referred the biopsy did a biopsy and sent it off to check. That GP was not the regular GP. The patient decided to contact the doctor herself, made contact via Facebook, and then started making other overtures, and a relationship developed. The GP did not continue to treat the patient, albeit did chase up the pathology results. The patient spoke to her usual GP about the relationship, and the patient happened to have a history of sexual abuse, and the usual GP was concerned, and as a result actually referred and made a complaint about the doctor that was in the relationship. In that case, the tribunal found that the doctor who had formed the relationship was guilty of professional misconduct, albeit they accepted that there was a low risk of repeat offending, decided it was still important to make a bit of an example of the doctor and imposed a 2-month suspension, and also imposed conditions on the doctor's registration. Other conduct is much less obvious, and it could really arise due to misinterpreting behaviours or poor communication. So it could be just comments about, sexual preferences, sexual history, just even looking at a patient that makes them feel uncomfortable. And unfortunately for the healthcare professional, you might really not have any great indication that the patient is feeling uncomfortable. An example is a GP who prescribed hormones to a female patient that I was involved in acting for, who was complaining of low libido. In an attempt to empathise with the patient, the GP talked about his wife having a similar problem. Unfortunately, whilst it was said quite innocently, the patient made a complaint about sexual harassment. So it can be just merely a comment. There are several avenues for making a complaint, depending on where the conduct happens. If you're working in a private practice or a hospital, yes.
The boundary of sexual harassment, you capture this.
Yeah.
I mean, either they they don't understand what they are doing,
Yeah.
or something going wrong in our society.
I think I'll get to that, but I think a lot of it is just knowing who your patient is, and people complain about lots of different things that could be quite innocent, and so you're very vulnerable. So it really is about making sure you have some protections around yourself, because particularly when your colleagues can make complaints as well. So that's one of the difficult areas, because the threshold is very low. And that is that there is a reasonable belief that there has been inappropriate conduct.
Remaining
And
time 4 minutes.
so it can be very difficult. But once you get caught up in the process, you've just got to get yourself out again. So, this is whether or not, there are mandatory reporting obligations. So you might not be the subject of the complaint, but you might have information that compels you to notify. So generally the complaints would, if they're outside of a work sort of situation, would be to the HCCC, or if it's really serious, which would be more than just a comment, it could be a criminal matter going to the police, or it could be a civil claim for damages, and that's particularly common where people are claiming that they've got a psychiatric reaction as a result. So dealing with a complaint, what should you do if a complaint is made? Even if it's not a formal complaint, if you're aware of circumstances that you think might lead to a complaint, you know that a patient is unhappy with you and it's more than something really minor, you should think about notifying, because your policy will generally cover you for a lot of things, even when a formal complaint hasn't been made. It can be the hardest thing to face, if you've been accused of something. The temptation is to think that it's very minimal and you can handle it yourself, or it might go away, but that rarely happens. So it is better to try and get advice. At the very least, speak to a trusted colleague and get a second opinion from that colleague. But the test is not whether you thought that you did the right thing or not. It's really going to be judged by somebody else. So just the process for managing complaints is different if it's in private practice or in the public system. They're governed by New South Wales health guidelines in the public system, or otherwise the bylaws of the particular practice or hospital. But essentially, if you are faced with a complaint, the first thing you need to do, other than notify your insurer, is to find out the detail of the complaint. Don't think you know necessarily what it is. You might be answering something that's not actually the subject of the complaint, or it might be a peripheral matter and you might make it bigger than it needs to be. But you're entitled to get full information about it in advance. So all of the regulatory bodies talk to each other. The complaint, if it's made to the HCCC, they will refer it on to the Medical Council, vice versa, and if they want to prosecute you, it will go through the NCAT procedure. So at the most serious level, your medical registration is in jeopardy and you need assistance.
1 minute.
Yep. So how do you try and minimise complaints being made? Patient selection is probably number one. You're not always going to be aware, but if you feel that it's just not right, you're generally, that's true. So while you can't leave a patient in the lurch, you should try and pass them on to somebody else. Good, clear communication is key. Maintaining good records, be a little bit self-serving, make sure that you document anything that where you're concerned, and get a third party involved. If it involves something that's quite intimate or tricky, that's what you should do. So essentially, it's really about trying to maintain good professional boundaries, knowing that complaints can come...
Thank you, Suzanne, but we're on out of time.
Yep, from many sources, and the reputational harm can be incredible. So make sure you get assistance. Thanks.